regarding dependent children, individual with special needs, and pets. Effective estate planning may help avoid costly conflicts between heirs. Elder Law PA handles such cases as Medicaid planning, wills, guardianship, probate and trust, estate planning, and special needs planning. In Florida, there are several strategies available to protect your savings and assets before you apply for Medicaid, as well as programs to offset the cost of home care, assisted living, and nursing homes. The Florida Supreme Court has declared that Florida Medicaid planning activities shall only be performed by an attorney licensed by the Florida Bar. At Elder Law PA, where they have the knowledge and compassion to protect your legacy. Contact Elder Law today for a peace of mind at 561-588-7512. That's 561-588-7512.
You are listening to the Ask the Experts show with host Steve-O. We will be right back with more experts in the field of legal, health, financial, and home improvement. Join us every Thursday from 6 p.m. Now, get ready for more Ask the Experts.
God, I love this show. I am so glad we can bring you South Florida's finest businesses. You know, a lot of people, it's really scary. They go to the internet. It's like the old Yellow Page days. You know, they go to the Yellow Pages and pick out who had the largest ad, thinking that was the best. And now people go to the internet and see who's got the best website. So with our show, what we do is we have a category. And with that category, we find the best. Like our next show right now, as I said, is an elder law show. We find the best law firm in South Florida for elder law. And you don't have to go to the internet to go find somebody. We've already done that, all the research for you. My next guest, I love this guy. I mean, don't take that the wrong way. I love this guy, and I even make sure now, because the show before ours was our assisted living show, and it was my fault screwing up, giving you the wrong information, but it's okay. But
I should be a producer.
Yeah. But Ryan Smoller, he is a senior partner at Elder Law, and I got to tell you, Ryan, I could not wait to get you on the show because a friend of mine in Dallas, who was a doctor, just passed away from COVID. And he always told himself, I'm too young. I don't have to start planning yet. You know what? I've got time. Well, we never know, do we? And I start thinking about you because what you do as an attorney is sit down with people and you do a roadmap. And you actually are taking all the pressure off the future off of them. Am I correct on that?
Totally. I met with a client today that, as you mentioned, they were on the internet and they said, we saw a phrase called pre-crisis planning. And I said to them, that is an absolute term. However, at the time you're meeting me, we are already in crisis. And it was a family that could have absolutely worked with me a couple of years earlier. We're still able to help them out. But Steve-O, you're correct. You don't need what I provide until it's too late to do it.
Right.
So it's a tricky situation. It's something people don't want to talk about, but absolutely it's valuable when you really don't even know, because most of my clients don't even realize the help I'm giving them. If they planned it early enough, they have nothing to worry about.
Exactly. And I got to tell you, Ryan, I'm going to tell you that he's in Lantana. So if you're in Hollywood, you're going, oh, that's too far. You know what? The way business is conducted now. We do Zoom. It doesn't matter where you live. What should matter is you've got a good attorney that's not going to charge you an arm and a leg, and this is basically all you do.
The client I was telling you about, I talked to the son in Westchester and the mother is in Aventura. So we were able to speak to the son on Zoom, and I'm going to meet with his mother in Aventura in Miami next week. So absolutely, technology is a wonderful thing. It
is. And funny, I was thinking about you yesterday. There's a very famous restaurant you're right across the street from, the Key Lime, which I went there and it was packed. But I got to tell you, you've got the most beautiful office building. I mean, it just stands out on that street. And I've actually been in your office. You've got beautiful a beautiful office. This, first of all, before we get started, because we're going to be talking about guardianship tonight, and boy, I'm going to tell you something. You definitely don't want to miss this. Ryan, tell everybody about your firm.
Absolutely. So Elder Law PA is a law firm that was established in 2015. As the owner, I focus, me and my staff, we focus our attention and our practice on advocating for the elderly, which can be anything from simple estate planning to asset protection and Medicaid planning, all the way through guardianship after someone loses capacity, and then unfortunately, the steps that need to be taken to legally handle an estate after death. So we cover the gambit of planning to administration after death.
And aren't the rules constantly changing now with Medicare?
With Medicaid, there's always little nuances that you may not be able to read in a blog that you've found online.
Right.
The income and asset limits are always changing a couple times a year. And so it's definitely a fluid area of practice, and it's one that I think I pride myself on having a lot of knowledge on a very segmented, very specific area of law.
You know, after the show last month, and because we promote the show also the week of, people have had concerns that with this new president that they're going to be losing some of their, I guess, some of their Medicaid. It's the prices are going to go up, and they're going to lose.
I mean,
is that true?
The state of nothing is set in stone.
Okay.
But certainly, if businesses are scrambling to compete with new tax laws, certainly services across the board may go up. And so skilled nursing facilities are included. There is definitely rumblings of talks about the estate tax exemption coming way down. And so maybe not losing Medicaid benefits, but certainly in planning, there are steps that can be taken to make sure at your passing, your assets are protected. Today's show, we're covering a little bit more guardianship, but as far as asset protection in Medicaid planning or in estate planning, what you're talking about is absolutely right on target with the new political type environment.
Well, we have talked about this before, and there's different types of guardianship. I think we even talked about this last time, that my friend's daughter, who was autistic, who turned 18, it was a nightmare, a literal nightmare, because the state comes in. They're no longer, they're now considered an adult. And the hoops she had to go through. Now, they say now 1 out of 8 children are born with autism. Boy, I got to tell you, there's a lot of parents who don't know about when their child turns 18 and how important guardianship is.
Yes, Steve-O, the same point applies as far as the planning early. If you do have a child, a special needs child, a child who in their adulthood is still going to rely on you for legal and medical decisions, it's absolutely important that you meet and consult with an attorney before they turn 18. It may be that there are other steps besides guardianship that could be taken, but if guardianship is absolutely necessary, you don't want to wait till they turn 18 because, as you mentioned, the process is a lot more drawn out. Starting before they turn 18, when they're 17 and a half is just the perfect time to begin that type of planning for a special needs or child with developmental disabilities who's about to be an adult.
Yeah, it's amazing because a lot of people aren't educated about it, a lot of parents, until it's too late. So I'm so glad we have you on our show to talk about it. When is guardianship appropriate? When is it not?
Yeah, and so I want to focus this question on really for our seniors in our elder community. Guardianship is an absolute last resort. I want to start there. There are the legislature in Florida said guardianship should be the absolute last resort. And what that means is if there's another way to get that person situated, that should be accomplished first. So guardianship is appropriate when the person can no longer appoint their own advocates, meaning your mother or father has gone to the point where they can no longer decide and sign on a piece of paper that they want their son Steve-O to be their guardian. Or I should say be their agent.
Is that because of dementia or
yeah,
that they can't think on their own?
Absolutely. It's basically based off a cognitive disability that is progressed so far that individual is not able to make legal decisions, not able to make medical decisions, and cannot sign or contract with anybody about who they would like in charge. So guardianship's appropriate when you're at the point where not only do your faculties have you lost your faculties, but you also haven't already signed advance directives. So a lot of people come to me and say, we need guardianship. And I say, well, no, your mother or father did great and they planned in advance and they signed advance directives appointing you. So luckily, this will be a very short consult and we can move on to different matters. But guardianship would not be appropriate in those cases, which is great because, as you mentioned, it is a long, drawn-out process. There is red tape, as with a lot of litigation and court administration. So it's appropriate in a very, very specific, small time. But when it is, it's necessary.
What does the court look at before a ruling on guardianship?
Yeah, so a couple of things. The court's going to be very, very, very protective of the person who's being alleged to be passed. A court's going to appoint 3 doctors to go evaluate that person individually. They're not doctors that are hired by their parents. They're not doctors that were their general practitioner for the last 20 years. They're court-appointed attorneys. I'm sorry, doctors.
Right.
So the court is going to take those evaluations and use those to make their decision. Then, as we were mentioning earlier, they're going to decide, is there a better way, an easier way that we can ensure this person is safe and secure? So the court's going to first look at medical records. They're going to have an attorney appointed for the alleged incapacitated person, and they're going to let them speak their opinion. And then finally, the court's going to decide based on all of those opinions and whether or not that person has what's considered a lesser restrictive means, whether or not a guardianship is absolutely necessary.
Is there a cost to the family for that?
Absolutely. So there's obviously the fee for the attorney you're appointing.
Right.
So my firm would take a fee. But then the court is going to say, like LeVar Burton on Reading Rainbow, don't take our word for it. The court's saying we're not taking anyone's word for it. We want these 3 doctors to go out and make their own independent evaluation. And those doctors are wonderful doctors that have degrees and have lots of experience, but they're also going to charge a fee just
Gotcha.
to go out and evaluate. There's also an attorney that the court is going to appoint for the person alleged to be incapacitated. And that attorney has to take a fee too. So guardianship not only is timely and a very intense matter, there are costs associated with it throughout. So really, Steve-O, if everyone listening at home takes away one piece of advice, it's plan ahead.
Right.
Plan so that guardianship is not the last resort. There are plenty of ways to get around or not need a guardianship, but really it just takes a little bit of advanced planning.
Well, listen, I told you we've got the best here. We're going to go to break. Ryan, give everybody your phone number where they can call your office tomorrow morning.
Absolutely. The number at the office is 561-588-7512. We also have a toll-free number, 888-552-7512.
We're going to go to break. We'll be right back with attorney Ryan Smoller.
At Elder Law PA, they bring you the support, experience, and knowledge necessary to aid you in determining how to distribute or manage your estate after your death. This can also include your wishes regarding dependent children, individual with special needs, and pets. Effective estate planning may help avoid costly conflicts between heirs. Elder Law PA handles such cases as Medicaid planning, wills, guardianship, probate and trust, estate planning, and special needs planning. In Florida, there are several strategies available to protect your savings and assets before you apply for Medicaid, as well as programs to offset the cost of home care, assisted living, and nursing homes. The Florida Supreme Court has declared that Florida Medicaid planning activities shall only be performed by an attorney licensed by the Florida Bar. At Elder Law PA, where they have the knowledge and compassion to protect your legacy. Contact Elder Law today for a peace of mind at 561-588-7512. That's 561-588-7512.
Hey, we're back. We're with Ryan Smoller, attorney Ryan Smoller. Beautiful offices, and I don't want you to misconstrue that that's going to up the money. He's in Lantana, but it's a beautiful office. But it doesn't, you know what? Like I said, if you're in Hollywood, if you're in Dania Beach, wherever, everything's done by Zoom now. You don't have to go to the office. But I got to tell you, I am learning every day how important it is, especially for elders, to get your life in order, because we never know. Ryan, we don't know from day. Did you hear that Hagler just passed away?
Marvelous Martin.
66 years old, and they think it's from the injection. They're pretty sure it is. Yeah.
I would have guessed it was the boxing career. Steve-O, we need to get you and do your documents.
I know. I'm sitting here talking about it. But, Ryan, you know what? Even when we talked about probate, I loved what you said. You try to keep your clients out of that because it could get really expensive. And I love how you run your practice. You're the owner of the firm. You try to make it affordable. You work with people. You sit down. You must have an incredible checklist in your head that people would never even think of to ask about.
Yeah, it's funny you mentioned that. It's definitely a checklist in my head. I've been practicing for over a decade. And so a lot of it comes natural, but at the end of a meeting or at the end of a consultation, my clients, I can tell, have learned something and definitely have a new peace of mind that allows them to either tell their their loved ones, whether they're their mother or father or their son and daughter, hey, we've done some significant planning that's going to help the family in the future and save a lot of time, money, and really, headache, to be totally honest.
Now, are there different types of guardianships?
Yes, certainly. So we mentioned guardianships for someone who is 17 and a half, about to
Right.
turn 18. Then there's your standard guardianship, which is for someone who has already been declared incapacitated or who is incapacitated and now needs the court to tell them as such. There's also a voluntary guardianship. So if you're getting older in life and you say, well, I know this is necessary. I don't want to go through the entire process. I'm going to just give up my rights to, let's say, a loved one. And then finally, there's professional guardianships where you may not have a loved one that can advocate for you. So once you've been declared incapacitated, the court's going to say, well, who's going to be in charge of this person? And so the court will actually appoint somebody who takes extensive guardianship training and whose entire career is based around caring and acting as guardian for individuals who need guardianship but don't have an advocate. So there are a couple different types.
Well, there's so many things that your firm does. I mean, we're talking about guardianship. We talk about elder law. We talk about probate. Wills are very important too, aren't they?
Yes, Steve, a will, I always tell people, usually husband and wives or mothers and fathers, I don't care what your wishes are as far as how you want to leave the money to your children, but put it in writing. Don't tell the oldest son, I'm going to give you all the money and you split it up the way you want it, because we know how that ends up.
Right.
And so wills are important because it's a way for somebody, a husband and wife or anybody, to decide how they want to leave their gifts to the people in their life who they love and who have supported them. So a will is an absolute crucial document in an estate plan that allows you to make a decision that you don't know how your family's going to react at your passing. You don't know what drama or what family dynamics there might be bubbling. Don't leave it to chance. Make a writing, execute it properly, so that your family and the state of Florida, the court, has a directive for how you want to leave not only your money but even your bodily remains. I have a client that wants to be cremated. His family says, well, no, we're going to bury him. And I say, look, leave it up to you. Don't let your son or daughter, who might have different religious or different personal beliefs than you, make that decision. So it is crucial, Steve-O. You're absolutely correct.
How often should someone have their will looked at? Because things change.
Yeah, it's a funny question. Most attorneys will blanket say, oh, every 5 years or anytime you change states. You should absolutely have it reviewed every couple years, but not necessarily need to be changed. I say, I kind of laugh when I say it, if there's anyone new in your life that you love or you hate, you should make a change. And obviously, if there's new children, so really it's almost like when you get new insurance, right? When there's a new life event. When you move, you should absolutely have it reviewed. When you get married, you should have it reviewed. When you have children, you should have it reviewed. When you retire, you should have it reviewed. It doesn't mean we're going to make a change, but there are little nuances you should be aware of. And shameless plug, I do free consultations and free document reviews. So elder law is absolutely here to make sure that the document you've done 10, 15 years ago is still living, breathing, and taking and carrying out your wishes currently.
Well, I got to tell you, it's there's so many people out there that think that you have to be a millionaire to do a will, but that's definitely not true. You don't have to be wealthy to do a will. No,
look, the state of Florida is going to charge you, I say the state of Florida, the court system, it's going to be a longer administration if you don't have a will. So a lot of times, unfortunately, the estates that end up taking more time and effort and thus costing more money are the estates that do not have a will. And it's exactly what you're saying. The person before they died said, well, I'm not wealthy, it won't be a big deal. The court says if you have over 75,000, you're going to have the same administration as if you're a billionaire. So if you have one piece of property worth, 150K, very, not a very expensive piece of property in South Florida, you're going through that same administration that these millionaires are. And so you definitely want to make sure that there's a way to get it done expeditiously. And that's certainly by creating a will or a trust, depending on your situation. So sometimes a trust is the absolute easiest way to administer your estate. You don't have to go to court at all. A will shorten the process. A trust will eliminate any need to go to court. So that's a really good point, Steve. I'm glad you had me.
Well, I've got
out.
a producer here that's a multi-millionaire, and I was really, he's looking around. I was really asking for him. What do you see in the future with Medicaid?
You know what? I always say the state of Florida, the legislature says, come on down to Florida. We want your tax dollars. So Florida is the most lenient, the easiest, I shouldn't say the easiest, the most lenient state to have your assets protected and you be approved for Medicaid. I'm dealing with clients in New York and New Jersey. I'm dealing with their attorney, and every time I give them a rule about how Florida works, the attorney's shaking her head saying, wow, in New York you could never do that. So we don't know how the rules are going to change, but we do know Florida is definitely elder-friendly and Medicaid-friendly.
Hey, this is the fastest 30 minutes. Give everybody your phone number again, Ryan.
Absolutely. So the toll-free number is 888-552-7512.
And Ryan will be back with us next month. I told you, he's so easy to understand, and we love him here at Ask the Experts. Ryan, thank you so much, and we'll see you next month, bro.
Thank you, Steve-O. It's good talking to you as always.
Always. And that's another Ask the Experts. We'll be back with you Thursday, 6 to 7. Everybody have a wonderful week.
Thanks for listening to the Ask the Expert Show, featuring interviews with local experts in the fields of legal, health, financial, and home improvement. Call our office at 888-574-6999 to become one of our experts on the show. And tune in again next week for more Ask the Experts with Steve-O.